Good morning, everyone. I'm glad to be here. I've been doing this for almost 30 years. I've been at this agency, Workforce Solutions, for 24, and mainly doing employment law, unemployment insurance, EEOC, FMLA, things of that nature. And most recently, I'm working on wage and hour cases that sort of is a topic of today's hearing, of today's presentation.
Please not hearing.
Yeah, I'm in court mode, I think. But, so, yeah, and I just want to say thank you for having me, and Los Alamos has always been one of my favorite towns in the whole state, and I have some relatives there. Or had some relatives there. They've moved, but thank you again for having me. I'm going to go ahead and share my screen with you so that we're all on the same page. Can you all see that first slide there?
Yes, sir, we can see.
Okay, great. Okay, whoops. Then I lost it. So, like you said, I work for the Department of Workforce Solutions, and this is the area that I've been working in the past 5 years is wage and hour. And part of that includes today's topics. What we're going to look at is salaried and exempt employees under the Fair Labor Standards Act and the Minimum Wage Act. Go briefly over the three types of salaried exempt employees under our state Minimum Wage Act. Go over this minimum salary threshold for someone to be considered a salaried overtime employee. And in the context, this will be in the context of what you may have heard or been referred to as the new overtime rule. There's nothing new about it, and we'll get into that shortly. And then I will briefly explain the difference between salaried exempt and simply salaried employees and how that affects your potential, bottom line. So salaried exempt employees under our Minimum Wage Act are those who are specifically exempted from the Minimum Wage Act. They're not entitled to overtime pay, which is time and a half, the usual rate that they get. And they're not entitled to a tipped minimum wage either, which probably won't apply in most cases anyway, but that's just one of the consequences of being salaried exempt. Under the Fair Labor Standards Act, we have a salaried exempt classification too, and this is based on salary, so it's a little different in the federal land. New Mexico's minimum wage is $12 an hour. But the federal minimum wage is $7.25 an hour. But like under the New Mexico Minimum Wage Act, these salaried exempt individuals are not entitled to overtime pay for working over 40 hours in a week. And they're not entitled to the tipped minimum wage in the federal law, which is $2.13 an hour. Now, let me just clarify right away at the outset here what my agency, Department of Workforce Solutions, does and does not do. We don't enforce the federal FLSA. That's not what we do. There's the U.S. Department of Labor is responsible for enforcing the FLSA. We're also not bound by the FLSA, and while we may use the FLSA as persuasive guidance in some cases, it's only for interpreting our own Minimum Wage Act. So we're not actually applying or enforcing the Fair Labor Standards Act as much as we are using it as a model for how we should, how our own state laws should be interpreted. The Minimum Wage Act has 3 exemptions that are based on someone receiving a salary. And what's unique about these exemptions is that there has to be a salary involved. And we'll get more into that later. But for shorthand, I use EAP, which stands for Executive, Administrative, or Professional. So executive are your managers. They're the ones that directly influence or set the conditions of work, and they have the ability to hire, fire, promote, demote, what have you. Administrative is non-manual work, which is something that involves a level of discretion and independent judgment. And then finally, you have your professional, which is someone who has an advanced degree or specialized skill or knowledge based on, a formal course of training or instruction. And we also include among our professionals the creative professionals, such as artists and writers and things of that nature. But so just remember EAP for that. The federal law has two additional exemptions. They have the EAP, like we have in the Minimum Wage Act, but they also have computer employees who do design, development, documentation, analysis, creation, and all that stuff with regard to computer systems or programs. And then there's a separate category in the federal law, which is for highly compensated employees. That means that they must make $132,000 and some change a year. And that means that all of these individuals in these types of roles are not covered by the federal law. As I stated, New Mexico's Minimum Wage Act does not have the computer employee or the highly compensated employee exemptions. Therefore, we don't apply them. We only apply the EAP as our salary-based exceptions to the minimum wage law. So the minimum salary threshold or requirement that applies to all three types, executive, administrative, and professional employees, is where you get the so-called new overtime rule. And the reason I say it's not new is because it's always existed. The only thing that is new about it is the minimum amount that someone must earn in order for them to be considered exempt from the Minimum Wage Act. So, for instance, I lost my PowerPoint here. Okay, there we go. It started July 1st of this year. A person has to make $844 per week, or $43,888 per year, to be considered any one of the three exemptions: the executive, the administrative, or the professional. And that went up, like I said, this last July. Before that, it was $684 per week. But that's not the best part for you, and I know this is not good news to somebody who's trying to put together a payroll, but it's going up again in January of next year. It's going up to $1,128 per week, which means that if you don't pay somebody at least a salary that works out to $1,028 per week, you can't apply the exemption to them, and they will be entitled to overtime pay, time and a half. So you want to make sure that if you don't want to fall in that trap, that you are paying them at least that much. Now, I will note that under the federal formulation, the FLSA, the highly compensated employee minimum salary requirement has also gone up as of July of this year, and it was it's currently now $132 and some change, but it's going up to $151,000 and some change in January of 2025. So be careful with that to make sure that if your intent is to apply the exemption, that you match the current salary thresholds. What is the difference between just a salaried employee and a salaried exempt employee? That's a good question. You could have somebody who is on a salary, but they're not exempt. In other words, I could have a delivery person who, instead of tracking the hours that they work each week, I just say, look, I'll pay you $1,000 a week to do all my deliveries in town, and that's how it works. But you're not necessarily a professional, you're not an administrative person, and you're not a managerial type of role. So if you do work over 40 hours per week, I owe you some overtime. And we would calculate that overtime at whatever your weekly salary works out to be, divide that by 40, and that is your presumed hourly rate. And we would apply the time and a half calculation to that to determine how much you should be paid for each hour over 40 that you work in a week. Compared to salaried exempt, which, as you know, if they do meet the minimum salary requirement and they are an administrative, executive, or professional role, then you could apply the exemption and not have to pay any overtime for hours worked over 40 in a week. And that's, so just calling somebody salaried, and the reason I bring this up is because I have had complaints come before me that they asked me to litigate for them in court, and I'm talking about employees, and the employer comes back and says, well, they're salaried, so they're not entitled to overtime. Well, you know, it doesn't work that way. They have to be both salaried and fit in one of the EAP categories for that to apply. So I know that you all are very, you have limited time, so I tried to keep this basic, but hopefully you might have some questions that we can talk about now and spend some of this time that we have to go over. I'm happy to do so.
Hello, Mr. Branch. My name is David Allen. I'm with SMSI. And we have situations where we have individuals that have been retired and they're working for us, and we have a vernacular for it called casual employees. So they work kind of when they want to and when we can get them, but they may work, a few weeks and work a lot. And then it may be months before they, work again. And this whole area has been always a dilemma for us because it's kind of random, sometimes when they work. So, any thoughts on that? I'm not sure I saw how that would fit into these categories.
So they work, a varying amount of hours per week based on what the project or the work is at the time that they need to do. And sometimes, does that go over 40 hours a week? If it does, then I would say that whatever you have figured their hourly rate to be, they would be entitled to overtime if they don't fall under EAP. If they do, of course, then you don't have to worry about it. But if they're not earning a regular salary, then that's probably not going to help you because they have to be both EAP and paid a minimum weekly salary amount.
And in this case, many times they may go months and not work because they're retired, and then come in and work, quite a bit. So, so the average weekly is based upon over the past year. How do you determine that?
Well, that's a good question. So there's a number of ways that I could look at that, but what I would do primarily is see if they have an established regular weekly amount that they get, and if they don't, it doesn't really help to take their hours over a period like a year and then extrapolate from that, because it's not going to get you the minimum salary threshold anyway that you need to make them exempt. So I would look at it based on each time that they start up working for you as a new period of employment, even though it may be an ongoing thing where they come back when you call them to. But each period of time, I would look at that as a separate period of employment and evaluate what their agreed upon rate of pay is for that period. and determine whether they make the minimum salary threshold for the time that you have them working, those individual increments. But, and I'm not exactly, I haven't really heard of casual labor in this kind of context before, but I'd be willing to sort of dig in a little more and look into it and get you some answers maybe after this presentation.
Okay, thank you.
Thank you, Richard. So if we have an engineer or a scientist who has advanced knowledge, that fits into the EAP, but they still have to have a set salaried relationship. Is that correct?
Correct.
Okay.
Correct. Otherwise,
To be
it's just
exempt.
as if they were a regular worker.
Okay, and none of this applies to contractors, correct? Overtime and so forth? Independent contractors who work for a company?
So that's a very good question. And those contractors are governed by the Service Contract Act, which is federal, and also some fall within the Fair Labor Standards Act. But interestingly enough, some federal contractors do fall within state jurisdiction. Now, here's the problem. The federal contractors are entitled to or required to pay their employees. I believe the minimum rate was raised to $17 an hour recently per executive order by the president, whereas the state minimum wage is only $12. My organization has no authority to enforce the federal contractor minimum wage. So if someone were to come to us with that kind of a claim, we would definitely tell them you might be better off taking this claim to the federal wage and hour office instead of us, because they could possibly get you more. But they're governed by a different set of rules. Other than sometimes, what if the employee said, no, I'd rather just go through the state and get my $12 an hour that you should have paid me under state law? Well, that we could enforce. But they'd have to be making less than that in order for there to be a violation. And any more, in federal contracting, they're usually higher up than $12 an hour. From what I've seen, I have seen them being paid less than the $17, but they're between 12 and 15 is what I've seen. And that's when we tell them, well, you might want to take your claim to the feds better than us.
Thank you. Other questions from our audience?
Hi, I'm Alice. I work with the LACDC, including the chamber, but I was just wondering about the classification under professional and who exactly that does and doesn't cover. I understand that it's probably on an individual basis, but like, for example, like a social worker or a preschool teacher off the top of my head, would those people qualify as professionals?
Generally, yes, because in order to be a social worker, you have to go through a course of study, usually at least a 4-year college to get that certification. So it would apply. Now, teachers, a preschool teacher, depending on what is required for that particular preschool, because some private preschools have different standards that they used to hire people with. It could also apply, but generally I would say not.
All right, so it's based on education required for the job or training for the job?
Training, skills, specialized knowledge, and usually gained through a course of intellectual study is how it's phrased in both the federal and the state formulations. Yes.
All right, thank you.
Mm-hmm.
Any other questions?
Hello, I'm David Martinez. I'm a co-owner of Hemis Mountain Brew House. We're a little worried because we're a small business, we've only been open for about 2 years, about meeting the new minimal for our salaried employees. Would you recommend that we maybe look at making them hourly employees?
Well, that all depends, and I really can't, every business has its own peculiarities and needs, so it would be hard for me, and I'm not a business person, I don't pretend to be, so that is a decision that you would need to make on your own, but generally, first of all, understand that it's somewhat difficult to successfully claim that an exemption applies to someone unless it's crystal clear that they're a doctor or a lawyer or something like that. Okay, are you talking about what types of employees are you talking about?
Well, like currently, I'm not only just the co-owner, but I'm also an employee. So I'm the general manager and I'm the acting chef. So I am salaried.
Okay.
So we believe my salary would go up in January. So we were wondering maybe it would be better for the business for me to be hourly.
I would imagine as a manager, you put way more than 40 hours per weekend, correct?
Yeah, I mean, last payday, I think, or past payroll is over 150 hours or something.
Okay, so that's something to consider. It may be, penny smart but pound foolish if you pick the wrong option, thinking you're going to save money, because if you go hourly, then you could possibly be costing more. I hate to put it in those terms, but did you say you were currently salaried and going thinking of going hourly, or the other way around?
No, I'm currently salaried, but we were
Okay.
thinking if that might be better for our business, but.
Yeah, that because they would have to give you an hourly rate, right?
Yes.
Put you on an hourly rate, and then so anything over 40, you're looking at time and a half for each hour worked, and with the hours that you're doing, it sounds like it could cost quite a bit. You might just have to just play out the math and take your average, number of hours over 40 for the past, 6 months and figure out, what you might be hitting each week, and what that would cost based on whatever rate you negotiate with them.
Okay, cool.
So,
Thank you. Other questions?
sorry.
Any employees here that want to ask questions, or managers?
I have a question.
Hi, I wanted to ask if you're seeing kind of a trickle-out effect for maybe contracts with the state and individual companies and coming back and saying, well, we need to increase the contract amount because we're gonna have to increase employee wages in order to cover all of this. Just curious what you're seeing in terms of a ripple-out effect of this going into place.
That's a good question. Is there a trickle down effect going on with respect to these types of positions, given the new salary thresholds? I'm going to tell you, I haven't yet. What I have seen is I've seen contracts for public works projects. That's where it's a government contract for construction of some government type of facility or building or whatnot, and there has been some pushback on some of the rates that are applied in those cases, which are different than what are required under the Minimum Wage Act. They require paying prevailing wage, which is based on sort of the average of all the rates set by collective bargaining agreements in the state, and saying that the amount of this contract that we received or that we were awarded isn't enough for us to be able to pay these prevailing wage rates. But I haven't yet seen something based on the new salary thresholds. That doesn't mean we won't. We might see that.
Thank you. I just thought of a question. If you have a nonprofit, and this may be obvious to everyone in the room, if you have a nonprofit and there's one employee, a director, who manages or volunteers, for instance, and their wage, let's say they meet the EAP guidelines because they're the manager of everything, but they make $50,000 a year. Would they be entitled to overtime pay?
For the volunteer portion of what they do?
No, just
Or-
as the sole director of the nonprofit, assuming they're putting in all kinds of hours, as a
Okay.
salaried director, would they then have to be paid overtime? Because the wage, the salary is, say, $50,000 underneath the January bump.
Oh, yes, they would. If they don't make at least the minimum salary amount, then they're not really in the exemption, the EAP exemption at all, and they have to be paid appropriately, even if they're on salary.
Okay, and does this apply to government, like state and county governments as well, or are they exempted?
So there is a specific exemption for government, state government, political subdivisions. So that includes all your counties and your municipalities. They're exempted from the Minimum Wage Act, except for one area. They're exempted from overtime. Okay. Now, a lot of, say, police departments and other employers do have collective bargaining agreements that provide for some sort of overtime arrangement or comp time, as you see frequently, but they're not required to be paid overtime under the Minimum Wage Act. The only thing that applies to government entities and their employees is the base minimum wage rate of $12 per hour. But if you have a city like Santa Fe, which has a higher minimum wage rate, $14 and some change per hour, employees are entitled to the highest applicable minimum wage rate. Now, we are allowed to enforce so if I have a case that's out of Santa Fe, normally I would apply the $12 minimum wage rate as what should be paid, but in Santa Fe, we can go after the higher rate there. But unlike the federal contractor rate, we're specifically not, authorized to enforce anything federal, just state, local, or municipal. So that's how that works. So no overtime unless there's a collective bargaining agreement.
Okay, thank you. Actually, your answer made me think of another question. You brought up comp time. If an organization agrees to offer comp time for extra hours worked rather than overtime, do we just need to have that in writing, that the employee agrees to that arrangement?
Well, that's a tricky question because there are a lot of these wage requirements that cannot be waived by the employee, even in writing. So it probably wouldn't relieve you of your minimum wage obligations, including overtime, which overtime falls under the Minimum Wage Act. So no, I would say that's probably not gonna work. In other words, we would take the claim, and if we would determine violations probably did occur based on that. Now, the reason why law enforcement is in a separate sort of category, law enforcement, fire and rescue, things like that, there are specific exemptions in the FLSA, which we do follow as persuasive in interpreting our Minimum Wage Act. so that the federal law says that you can, in lieu of paying time and a half to these employees, you can do it through comp time. But it's only a narrow set of employees. It's just not general workers. It's basically law enforcement and things of that nature.
Okay, thank you.
Hi, another question. Benefits then have no bearing on the salary number itself, right? So do you expect to see employers slashing benefits in favor of raising salaries, or is that not something that would happen? That would be my logical thing as an employer.
You know, I don't know what they're gonna do, and you know, that might be my knee-jerk reaction if I were, you know, the business to do that. But I'd have to really take a long, hard look at whether I'm gonna be saving money or it's just gonna be coming out some other way, you know. For instance, if I look, you know, take them off salary and make them hourly, I really want to look at what their history of working overtime really is in that role, which is going to be difficult because as salaried individuals, you probably haven't kept close track of their overtime work, you know, as long as they do the work, right? So that could be difficult. So you would have to almost start to do kind of an analysis of what you have seen them work to figure out what your liability might be. And slashing benefits, you know, you want to keep good people, so I don't know if that's a good strategy or not, especially since it's been difficult, what I hear from employers these past couple of years, just getting somebody with a pulse in the door, you know, to do the job. So you might want to, you know, I really can't predict what they might do, but I would urge caution if that's where they're thinking of making up the savings on that, you know.
All right, thank you.
Any other questions? Okay, hearing none, seeing none. I think you have answered our questions, Richard. Was there one question you were going to get back to us on?
The casual
Yes,
employee bit, I can see how that would play out specifically in terms of salary and the you know, type of work that they do. And I assume direct that to you, correct, Sandy?
Yes, sir. Yes, sir. And as to
Okay.
how we can comply with the law and still keep the spirit of the agreement, you know, of a retiree who doesn't want to be working all the time. So,
I believe me, I'm almost to that point. I should start looking into it since now.
well, and
But well, if that. Go
thank
ahead.
you so much for your gracious, you know, time this morning. We appreciate you sharing your knowledge. It's just so helpful. We like to be on the front end of staying in compliance. So this is, I think this has been pretty helpful to our audience. I see some nodding of heads. So we thank you, Richard, and hope you come to see us up here in Los Alamos sometime soon.
Okay, and if you think of any other topics you want me to address, you know, just let me know and we can you know, put something together for you. Thank you.
Thank you, sir.